Legal Considerations, Part 2. Tort law. A wrongful act other than that of a breach of a contract. We have state medical practice acts. Each state has medical practice acts that regulate the practice of medicine within the intent of protecting its citizens from harm. They govern licensure, standard of care, professional liability, confidentiality, and torts. They may regulate personnel employed in the ambulatory care setting. A medical assistant may be regulated under the nurse practitioner's license, a physician's license, or by their own state's requirements. Medical assistants are considered an agent of the employer they serve, and as such they must be cautious that their actions and their words become binding for their employer. Some states regulate medical assistants' ability to perform certain clinical functions. To better understand tort law, we must consider the standard of care. Negligence is defined as the failure to exercise the standard of care that a reasonable person would exercise in a similar circumstance. Negligence occurs when someone experiences an injury because of another's failure to live up to their required duty of care. There's the 4 D's of negligence. Duty, the duty of care. Derelict, the breach of the duty of care. There's direct cause. A legal recognizable injury occurred as the result of the breach of duty of care. And damage, wrongful activity, must have caused the injury or the harm that occurred. Negligence is the primary cause of malpractice suits. Malpractice is professional negligence. A medical assistant's role in negligence. Torts are intentional or negligent. And intentional torts are deliberate acts violating another's rights. Negligent torts are not deliberate. They are the result of an omission or a commission of an act. There are 2 Latin terms that can be used to describe the aspect of negligence. Res ispa liquitur, the thing speaks for itself. What this means is if a doctor is doing surgery and they are doing a hysterectomy and they accidentally nick the bladder, well, that pretty much speaks for itself. The other saying is respondit superior, that's let the master answer, and that is that the providers are responsible for their employees' actions. Some other things that fall under tort law and the standard of care is battery. This is the unprivileged touching of one person by another. This is why it's so important to always ask permission of a patient to do things to them. Defamation of character. This is injuring another person's reputation, name, or character through spoken or written words. What falls under that is, under defamation, is libel. Libel is the false or malicious writing about another. Slander is the false or malicious spoken words. Invasion of privacy is unauthorized publicity of a patient's information. Informed consent. Every patient has the right to know about all aspects regarding their care. The nature of any procedure and how it's going to be performed. The possible risks as well as the expected outcomes of any procedure. Any other methods of treatments and those risks. And there's risks of no treatment. Consent and legal incompetence. Legal incompetence means that the patient is found by a court to be insane, inadequate, or to not be an adult. We have mature minors and emancipated minors. A mature minor is a person, usually under the age of 18, who are able to understand and appreciate the nature and consequences of treatment despite their young age. An emancipated minors are younger than 18 years, who are free of parental care and are financially responsible, married or become parents, or join the armed forces. Risk management. Practicing good risk management makes the MA and the provider less vulnerable to litigation. Some ways to avoid incidents that may lead to litigation: perform only within the scope of your training and education. Comply with all your state and federal regulations. Keep the office or the clinic safe and the equipment in readiness. Never leave your patient unattended. Keep all patient information confidential. Follow all your policies and procedures established for your office and clinic. Civil litigation processes. Subpoenas. This is an order from the court naming a specific date, time, and reason to appear. Some records are protected and will require a court order. HIPAA requires written policies regarding the release of information. In the litigation process, there's usually a time of discovery, which follows the subpoena. This is the time in which both parties are allowed to access to all the information and the evidence related to a case. Interrogatory, a written set of questions that can come from either the plaintiff or the defendant that must be answered under oath and within a specific time period. A deposition is an oral testimony taken with a court reporter present in a location agreed on by both parties. An expert witness is a provider or a member of their staff that may be called to testify in court on the standard of care. Pretrial conference. There's alternative dispute resolution. Mediation allows a neutral facilitator to help the two parties settle their differences and come to an acceptable solution. Arbitration allows the neutral parties to settle a dispute. Arbitration can be binding or non-binding. A binding arbitration, both parties agree at the onset to accept the neutral party's decision as final. A non-binding arbitration, the case can look to the courts for settlement. In the trial process, you can have a trial held by just a judge, or you can have a trial held by judge and jury that can make the decision. You can see outlines of civil case processes in your text. Public duties. Reportable diseases and injuries. You can see a possible list on the CDC website. All medical providers have a duty to the public to report diseases and injuries that jeopardize the public health and welfare. These include abuse, such as child abuse, intimate partner abuse, which is not as well defined, and elderly abuse, gunshot wounds and knife wounds, as well as certain communicable diseases and sexually transmitted diseases. Careful documentation is critical. State laws are fairly specific in mandates to report child abuse, but laws related to elderly abuse and domestic violence are not as detailed. Good Samaritan Law encourages healthcare professionals to render aid at the scene of an accident. You must only respond within the scope of your knowledge and training. Advanced directives. Advanced directives are legal documents in which a patient indicates their wishes in the case of a life-threatening illness or serious injury. Physician ordered for life-sustaining treatment, POLST. This is a form that is to be completed by a healthcare provider based on the patient's preference on the type of life-sustaining treatment that they would want and medical indications. Living wills and healthcare directives. The patient desires to make it known in advance their choice related to healthcare, especially when death is near. They will have a living will or an advance directive. Durable power of attorney for healthcare. This document allows a patient to name another person as the official spokesperson for the patient should they be unable to make their own healthcare decisions. And Patient Self-Determination Act of 1991. This applies to all healthcare institutions receiving payment from Medicare or Medicaid, and it requires that all adults receiving healthcare from these institutions be given the opportunity to provide information about their wishes in an advance directive. You can see samples in your text of each one of these. Changing society values have contributed to an increase in the lawsuits in the medical practice. Patients are more aware than ever of their rights, especially of those of confidentiality and the right to privacy, consent, and the records ownership. A healthy relationship between the provider and their patients and between the medical assistant and the patients, as well as respect for the patient's rights, reduces the likeliness of lawsuits.